Hello and welcome to a short bulletin of Legal Wrangle. This is a quick, brief format of Legal Wrangle in which we bring you swift updates of important decisions from the Supreme Court and the High Courts of India in the last couple of days. In this bulletin, we have cases relating to prominent assessees like Kingfisher Airlines and Mr. Arun Puri, the corporate baron of the India Today group of publications, and other important issues relating to service tax exemption and Section 80 HHC of the Income Tax Act. This final verdict by the Supreme Court on Section 80 HHC cleared hundreds of cases in one shot. But let's go to the Kingfisher case.
The assessee is the now defunct Kingfisher Airlines, facing a number of legal battles.
The bankrupt Kingfisher Airlines has lost its battle for Rs 372 crores in the Supreme Court of India. Manit has the case details.
The airlines had deducted tax at source from employees' payment but not deposited the amount with the government. When the department ordered it to do so, the airlines initially admitted the liability but later pleaded violation of principle of natural justice that it was not given an adequate opportunity of being heard. The Karnataka High Court upheld the revenue demand and directed that the TDS and interest thereon needs to be recovered.
The Supreme Court has now dismissed the assessee's special leave petition, holding that there is no legal and valid ground for interference. The airlines is an assessee in default and will need to pay up. Of course, how the department will recover the dues is another big question. Let's quickly move on to Mr. Arun Puri's case.
The assessee is Arun Puri, editor-in-chief of the magazine India Today and the chairman of the India Today group.
The interesting question in Mr. Arun Puri's case was whether prize money he had received is it taxable as a revenue receipt? Let's go to Manit for the facts.
Mr. Puri had sought exemption of the award money received by him as B.D. Goenka Award for Excellence in Journalism. Revenue disallowed the exemption, holding that this award money was not covered by the exemption provisions of Section 1017A, meaning it was neither an approved award nor was it from the central or state government.
The Delhi High Court held in favor of the assessee, holding that the award money being a one-time payment of a personal nature, like a gift, without any element of quid pro quo, has to be treated as a capital receipt. Our next case relates to service tax and involves a stem cell bank, which allows a mother to store the stem cells from amniotic fluid for her baby's future use.
The assessee sought service tax exemption with retrospective effect.
The Madras High Court decided whether an amending notification could operate with retrospective effect.
The Central Board of Excise and Customs issued an amending notification number 4 of February 2014 exempting tax and services provided by cord blood banks. The original notification, which was thus amended, exempted tax on healthcare services by a clinical establishment. The assessee filed a writ petition to prohibit the department from collecting service tax for the prior period as well by claiming that the amending notification was clarificatory in nature and would operate with retrospective effect.
The Madras High Court held that the amending notification will operate from the date of the amendment. Amendatory statutes, like original statutes, will not be given retroactive construction unless the language clearly made such construction necessary. The amendment will usually take effect only from the date of its enactment and will have no application to prior transactions unless it is clarificatory in nature. The assessee's petition was dismissed. Our last case deals with the Supreme Court's decision on Section 80 HHC 3. With this verdict, the Apex Court settled an ocean of pending litigation relating to deduction under the amended Section 80 HHC 3 before it went out of statute.
The assessees were exporters with a turnover of more than 10 crore rupees.
The Supreme Court in this landmark decision considered the validity of the amendment made to Section 80 HHC 3, which allows exporters to avail deduction on export profits. The court clarified the key judgment of the Gujarat High Court that this amendment, which created two categories of exporters on the basis of turnover, could not operate retrospectively as it was ultra vires Article 14 of the Constitution of India. Let's go to Manit for some background.
In April 2005, Section 80HHC3 was amended, which created two categories of exporters: those with an export turnover of less than Rs 10 crore who were entitled to claim deduction on the full amount of DEPB credit and DFRC profits, and on the other hand, exporters with an export turnover exceeding Rs 10 crores who could claim 80HHC deduction on DEPB and DFRC profits, only if two more conditions were satisfied. While the amendment was advantageous to the exporters having less than Rs 10 crores turnover, the two conditions imposed on exporters with high turnover were not. What's more, this amendment operated with retrospective effect. Naturally, the affected exporters with the higher turnover challenged these restrictive conditions operating with retrospective effect on all pending assessments. The Supreme Court transferred all such writ petitions pending in various high courts to the Gujarat High Court to consider the constitutional validity of the retrospective amendment. The Gujarat High Court, in a landmark judgment passed in July 2012, held that the amendment could not operate retrospectively as it was ultra-vires Article 14 of the Constitution of India. It placed two assessees in the same class on a different footing. Revenue challenged this judgment before the Supreme Court.
The Supreme Court clarified the Gujarat High Court order and effectively quashed the two restrictive conditions imposed under the amendment to Section 80HHC on exporters with the higher turnover of more than Rs 10 crore. It held that both the categories of exporters shall be treated similarly under the Income Tax Act. In another unrelated decision on the same section, the Supreme Court held that Section 80HHC deduction is only applicable on export profits.
The assessee is an exporter of marine products as well as being in the business of financial consultancy and trading in shares.
Revenue disallowed the assessee's claim of Section 80HHC deduction on its profits because the assessee had reported export losses but shown overall profits from its consultancy business. The Supreme Court held that the deduction permissible under this section was only a deduction of the profits of the assessee from the export of goods. By the very terms of this section, it was clear that the assessee was not entitled to any benefit thereunder in the absence of any export profits. Well, this brings us to the end of this short Legal Wrangle bulletin. Please do let us have your feedback on editor@tiol.in. To remain updated, please register with the TIOL tube on YouTube. It's free. Thanks for watching. Have a nice day.